8th, 2021 Shallow Law Weekly Wednesday webinar. And for all of you joining for the first time, I want to welcome you. For those who have been joining us every week, I want to thank you for your participation. And let's give it a few minutes to have people join and log in, and then we will get started with what's the latest in immigration this week. I hope you all are getting ready for the holidays and finalizing all the things you need to start the new year. And hopefully we'll have better news in 2022 on immigration, and there will be some movement on all sides. So let's get started. We're going to talk about the continuing resolution, prevailing wage processing, and some things that you can do. So Congress passed a continuing resolution, as you know, to fund the government through February 18th, including continued support for Afghanistan. No immigration provisions were included or updates to the EB5 program. Congress is still considering the social spending bill with the goal of passing the bill before Christmas. Announced continued meeting with the Senate parliamentarian to determine whether the provisions comply with the Byrd rule for budget reconciliation. The proposal has to have an impact on federal spending and revenues, and that impact, this is the Byrd rule, cannot be merely incidental to its non-budgetary goals. So that's how such as immigration provisions, can be allowed to pass through budget reconciliation. And the reason why that's important is otherwise you can have, that's the only way the Democrats can get anything passed. They do have the majority, but they don't have, there are ways in which people who oppose it can stop it. And that is a discussion for another day on how nothing gets done through Congress because of the filibuster and other things. But the Treasury Secretary, Janet Yellen, has given Congress till December 15th to raise the debt ceiling. I think there was some support today on that issue, so for temporarily, so we can pay the bills. The immigration provisions have changed significantly over the course of negotiations. So we have to see how that plays out in the end. Excuse me. Thirsty day. So DOL, for any of you that are going through the PERM process, you know that the one aspect that is taking an exceedingly long time is DOL prevailing wage processing times. This has been happening over the course of, I would say, like a year and a half. We've seen that increased processing times, which otherwise the PERM process could be processed pretty quickly. And we have some tips. So if your employers are interested on how they can kind of maximum leverage to their processing times so that you don't have to have such a wait every time you file a PERM, then have them check out our special PERM webinar that we will host mid-January. This could be very good. It gives you tips that you There we go. So that they can leverage and expedite their PERM processing. That's really critical. So the increase in prevailing wage applications for like H-2A, H-2B have diverted resources. So temporary programs have regulatory requirements on processing times. They have to process those pretty quickly because of the way the H-2B and H-2A are structured. So they take the priority. So DOL has an interim rule on the final computation of prevailing wage levels, resulting in lawsuits. So when the rule was issued, the National Prevailing Wage Center received 10 times as many prevailing wage requests based on alternate wage surveys. While we can't increase the process time, we can avoid further delays. So we can't decrease the process, we can avoid further delays. So they're trying to respond very quickly for requests for information. provides sufficient details and information about job duties and requirements to assist the analyst in determining the proper occupational code and level. And the new form 9041, which is a prevailing wage form, has only been utilized since May 2021, and processing times are close to 6 months. So employers are now just seeing new PWDs based on that form. So like I said, there are ways that we have been looking into this where employers, especially those that are going into that are doing the PERM process, can really make sure that they maximize a number of things in terms of filing PWDs, so that you're not shackled by the very long processing times. So please tune in for our PERM special. Holiday travel considerations. Now, visa appointments are still limited, and I understand for India, they're just doing emergency appointments right now still, and they're not granted to all visa categories. And current travel bans are applied to 8 countries in South Africa, but conditions could change quickly with the new variant. I just tell everyone, if you're going to travel, you've got to be very cautious. There's no guarantee. We don't know what the future holds and how any other new variants can play on. So you just must, take that into consideration before you make travel plans. We've received some questions on automatic visa revalidation. So we want to explain that a little bit. If a non-immigrant with an expired visa returns to an American port of entry to seek readmission after a departure in the US, the rule allows for automatic extension of the validity of the expired visa. The validity would be automatically extended to the date of the application for readmission. The individual must possess an unexpired I-94 card or an I-20 for an F1 student. They must be returning from a trip of 30 days or less to Canada or Mexico, contiguous territory. So it doesn't apply if you're coming from Europe or some other country. Must have maintained non-immigrant status and are returning to resume the non-immigrant status. They have a valid passport and doesn't require an inadmissibility waiver, and have not applied for a new visa abroad, or not from a country designated as a state sponsor of terrorism. So this doesn't work if you're going to Canada or Mexico to apply for a visa and the visa is denied. But it does work if you're going there for some other reason. Your I-94 is valid. You have no inadmissibility issues, and your travel was for 30 days or less, and you're still maintained your non-immigrant status, and that is the same status you're going to resume when you return back to the US. So if you're changing status, that's not going to help. This rule will not help. Some individuals change status may be readmitted using AVR, the new visa type. For example, a worker enters on an L1B, but the employer files a petition a couple of years later to change to an H1B and request an extension of stay. The worker is granted the approval and the new I-94 by the USCIS. He could travel to Mexico or Canada without the H1B stamp, because the L1 would be considered automatically extended and converted to an H1B, allowing him to be readmitted under the H1B status. This is not a substitute for stamping if you have to travel abroad, but just allows you to be readmitted to the US after temporary travel to Canada or Mexico. CBP does not issue a new I-94 when permitting non-immigrants to come back into the United States under this rule, on the presumptive logic that they have not been newly admitted, but merely readmitted to resume the same status. In other words, they are treated as if they have never departed. And next week, we're going to have a special guest. In light of all the discussion about traveling, temporary travel to Canada or Mexico, we're going to have Venkat, who will give us an update on stamping in Mexico. So if you've got friends that are looking to do that, spread the word. This is always a very popular topic when we cover it, especially now during the holiday seasons. So I would like to invite our moderator, Shekhar Challa, to start answering any questions, if there are any questions.
Good afternoon, everybody. How are you all? How is Lakshmi? I am traveling. Can you all hear me?
Yes.
Okay. So I'm traveling, so you can see a nice background behind me. I had to get up at 3:30 this morning. So if I look the way I look, that's what it is for. Just wanted to clarify. Anyway, there are some questions. So let's look at the questions. I think there was a question from YouTube. Take the order in the order it is received. Sweet Seller, like the name. Visa Bulletin has been effective only for 8 days, with EB2 barely ahead of EB3 by 4 months. Why does Charlie state that EB2 will slow down?
Well, you should, Sweet Seller, you should take a look at our webinar where we covered all the factors that go into the Visa Bulletin. It's not just, I mean, it would appear that there's somebody behind the curtain that's kind of doing stuff, but there's a number of factors. It's how many permanent resident applications are being processed at the consulates abroad. And I think last week we reported that EB3 is at an all-time high in processing at the consulates abroad. How fast is the USCIS processing the applications that are currently pending? And so he factors that, and he says it works like a budget. So please look at that webinar where we kind of explain some of the factors that go into the Visa Bulletin.
All right, it's got a follow-up. He or she, I don't know, Sweet Seller. Visa Bulletin, let's see. Follow-up is, it is mentioned the Consular Processing is slowing down AOS processing. Are they not accounted on same categories? Can you explain how Consular Processing slows USCIS?
It doesn't slow USCIS, it impacts the Visa Bulletin, okay? So it's counted the same. So you've got the USCIS processing those who are in the United States on adjustment of status. You've got consulates abroad, which, the processing time it's ebb and flowing with the new variants and whatever the country conditions are on COVID. So they're still working in very limited places, but they have accounted for a lot of the EB3. There's been an increase in EB3 processing with consulates abroad. So that affects the Visa Bulletin because there are, again, more people that are accessing or utilizing that particular category. That's the interplay.
All right, this question from Hardik Panchal. If I file a marriage-based green card application, including change of status, both are in US in next few weeks, how fast can I get it approved? Asking to find out ways to travel to India due to family medical reason. Okay.
Well, here's a couple of things that I would tell you. First, are you filing on the basis of marriage to a US citizen? If you are, then you would be able to file the immigrant petition, which is the I-130, and the adjustment of status at one time. There is a tremendous delay in issuance of advanced parole. That is particularly important if you are on a status other than an H or an L. If you are on an H or L, then you've been issued the H or L from the consulate abroad, we will attach a memo that you can look at or a YouTube video link that talks about travel considerations and utilization of the Dropbox and other things.
So here are some responses from him. First, to your question, he said yes. And I forget what you asked.
Yeah, I
Second
asked him if he was married to a US citizen. He said yes. So that means that he would get, he could file the adjustment of status, allowing him to get advanced parole and EAD, but it's taking, I think, 6 months or longer for issuance of those. So it's not something that's going to happen overnight.
He is on a student visa and it is expired.
Okay, so if you're on a student visa, then you cannot travel without, if you file your I-130 and I-485, then you cannot travel without your advanced parole. Otherwise, you would have been deemed to have abandoned your immigrant-based adjustment of status application. So it is especially, in your case, it is imperative that you don't travel until you get the advanced parole. The only exception to that is H's and L's.
And the last thing is there a way to expedite by paying premium processing?
Not yet. We're all looking forward to that, but not yet.
Okay, Mr. Hardik. That's your answer from the attorney. Next one is from YouTube, Soham, asking, I keep hearing that USCIS did not count properly the EB3 count, and thus we can see EB3 advancing start January bulletin. Is that true?
I have not heard anything, but I will look into it, that they have not counted EB3 properly, but we'll check that and get back to you.
Thank you, Hardik. I
So
hope
stay
you
tuned for next week. We'll have that answer next week about the EB3s.
All right, next one is from YouTube again, Ram Raju. EB3 I-140 downgrade pending from previous employer. It was amended, filed with I-485. Can I interfile with an approved EB2 with my current employer, different employer? Thanks in advance.
There's a lot of things in that question. Number one, if you filed an amended versus filing a new, that means you converted your previous EB2 to EB3. And you can't interfile with that, number one. Number two, if you filed a new I-140 instead of amending, then you can interfile if you've changed employers after the I-140 is approved, the I-45 has been pending 180 days. Even if you change employers, because you're changing employers pursuant to portability under AC 21, you would be able to interfile at that point. So you could do the I-485J and do the interfile presumably at the same time.
Okay. You can see in the chat that our team has put the link for the webinar that was Lakshmi had mentioned. New guidance on COVID vaccination requirements for travel. I guess that's very important. So, all right, let's look at some more YouTube questions here. Is it necessary to withdraw the previous EB3 AOS if a new EB2 AOS? I said maybe with a new. What are the pros and cons of withdrawing versus not withdrawing?
I wouldn't withdraw. You're required to withdraw. So why do you want to withdraw something that's pending when we don't know what's going to advance? At some point, when they're ready to make a final determination, USCIS will ask you, which one do you want to use? So I would just wait for that.
Okay, next question from Mukesh from YouTube. Hello, madam. Have filed EB3 downgrade AOS last October 2020. Have EB3 and EB2 I-140 approved. Medicals interfiled in September 21. Requested FOIA and found my birth certificate, both I-140s, medicals, I-693 attached to my EB3 I-45. My PD is June 2012. Saw handwritten notes in both EB2 and EB3 I-140s that ETA 9089 now linked to EB3 I-140. So I wanted to ask, shall I interfile to EB2 or refile new EB2 AOS as I have as I hope to be current in EB2 India starting January 1st, 2022.
I would interfile instead of filing anew, because remember, if you've been paying attention to our YouTube videos, our weekly Wednesday webinars, I did talk about how, although they won't make a final determination, they do some preliminary review when you file your adjustment of status, even if you're not current. So you don't want to start that timer all over again. You want to leverage the initial review that's already taken place with your existing adjustment of status. So I would interfile.
Yeah, he just added saying my case is pending in NSC.
Okay, good. Better than TSC, right? Because we know the Texas Center is even though NSC is taking long, Texas is taking even longer. So, but these processing times and numbers should be improving, because you remember from August, they started processing, I think, Kara, is it 6 or 7,000 per month? I can't remember.
He says NSC is processing like 30 to 40 I-485s per day.
Yeah, I think the number per month, and like I said, Kara will list it. They just increased that coming August. So I think we'll see, and that's also going to contribute, by the way, to the backlog of the visa bulletin, because the more that's being allocated, the quicker the visa bulletin gets exhausted. So it's good in some ways, bad in other ways, but for those of you who are current or plan to be current soon, you want them to process them fast so that you don't get caught up in a retrogression.
All right, next question from the box. Hi, Lakshmi. I have already started using GCEAD from October with current employer, and my new employer is asking to start consular processing for H-1B in parallel, and I can still join on GCEAD. So will that cause any concern, and how consular processing for H-1B works?
Right, so you can either do one of two things. You can, and I don't know why, I don't know why they want you to process consular processing. I guess maybe because you started working with them on an EAD instead of your H-1B. So your H-1B, you violated status because you worked with an employer other than your H-1B employer on your EAD. So they're trying to do consular process. Consular process is just, when you file an H-1B, two things happen. The USCIS adjudicates the H-1B to make sure it meets the criteria outlined in the regulations. The second thing they do is, as a benefit, they will you can either get a change of employer, amend your status, extend your status. You can do all these things in the United States. You can also choose consular processing. And the reason for that is, and a lot of times there may be a number of reasons to do that, but that way, you have that as a safety net. I'm assuming that's why your employer is wanting to do that, and it's a smart move. So if anything should happen, as long as you can get an appointment somewhere, you would be able to go out of the country, process your H-1B visa. And by the way, if your H-1B visa is still valid, you may be able to use that to re-enter the United States and not have to process a new H-1B visa. But you definitely have to consular process, and you would be able to re-enter the United States on an H. So it's for safety net purposes.
All right, next one, another if derivating applicant travels on AP while primary is on H-1B, will entry through port by derivative would also change primary status to pending OS, or primary would still be on H-1B?
Yeah, no, the derivative in H-4, because they're not the primary applicant, their activity does not impact the H-1B status at all. Whether they travel on AP, whether they work for 2 or 3 people on their EAD, None of that affects the H-1B. The H-1B's activity, however, can impact the H-4s because they are the primary. So they are the ones that are the reason for the allocation of that status to begin with. So they have to maintain their status.
Okay, take some questions from YouTube again. What are the advantages of filing new AOS if the dates are current only on date of filing charts?
Well, if you can, I always tell people they should interfile instead of filing a new AOS. Sometimes you have to do that because of a number of other reasons. But I always find that if you can interfile, that's probably the most expedient way to do this.
Second question is from YouTube. Shivkant Ranade. My spouse's employer is not be able to pay for attorney costs for filing H1. Can we pay for the attorney costs for helping submit the H1 application? Would you recommend filing without attorney help?
No, I would never recommend filing without an attorney help because there are a lot of nuances with the H-1B processing. So you want to make sure not only you get an attorney, but you get one that knows what they're doing. Number one. Number two, there are certain fees, filing fees that cannot be paid by the employee. As far as the legal fees, as long as, so whatever is the prevailing wage, let's say the prevailing wage is $50,000 and the employer is paying the employee $60,000. If you deduct the lawyer fees from the wage that's being offered, as long as that's still above the prevailing wage, then you're good. But if after deducting the lawyer's fees, the offered wage falls below the prevailing wage, then it's impermissible.
All right. Let's see. More YouTube questions. Don't think we have any more YouTube questions, but I think it's time to revisit the EB5 visa status, just to give some.
Oh yeah, so now because of the continuing resolution, those who want to take advantage of filing the EB5 for direct investment can do so until February, what is it, 14th that they, it's February, I forgot what date. I think I'm thinking 14th because it's Valentine's Day, but, 18th. So through February 18th, you can file without any issues. So that's good for those people who are just getting started with the process, don't have a 2012 or, that's a good avenue to explore getting your permanent residence in a faster manner.
Yeah, so if any of you are interested in EB5, like I've been saying that, just send an email and directly to me, to info@Chella, and I'll be glad to call you and talk more about the availability of the project and the opportunity to invest as a direct EB5 applicant. There's some advantages for sure. So you would like to explore that. So let me know and I'll be glad to call.
And I think somebody's asking if they can file the direct EB5 with 500,000. Yes.
Yes.
For a limited time until February 18th, you have this opportunity to leverage the lower threshold for EB5. So Mukesh, this is a good time.
You may be wondering why we are bringing EB5. Well, that's part of the immigration visa, right? In the A to Z immigration, EB5 is one. And the reason we've been, giving you that information consistently is because the fact that it is reduced from 900 to 500. That's why. And it's only for a limited time. We all thought it was December 3rd. Now it's extended to February 13th. I don't think it'll be extended. That's my personal feeling. Now, I'm not, magician here. But, by the time the Congress will have a full-fledged budget and then hopefully they'll make decisions. if there are no other distractions in the coming year. So it's a good opportunity. Buy
And
one.
that- Right. And now that the EB5 Regional Center program, the pilot program, is on hold, direct investments have really always been historically a very small segment of EB5 filings. And with the mass majority of the petitions that are currently with the USCIS, because they're on hold, this is a chance that the EB5 Direct may start processing those faster. So it may be not only at a lower threshold, but until the reauthorization of the EB5 Regional Center takes place, you also have the faster processing time.
Yeah, I think the current EB5 investment minimums that you had asked, as I said, direct, only direct EB5 is currently on. That's the only program that's currently on, which has always been on. It's the regional center program that is not on. So, as a direct EB5, you can invest in a regional center project that originally started, project that started for regional center investors, but they have made some changes so they can accept direct EB5 applicants. So such projects you can invest $500,000. That's the minimum investment right now.
Yeah, there are a number of centers that have restructured some investment mechanisms to allow for EB5, not EB5 Direct. And remember that there are some subtle regulatory differences between the regional center and a direct EB5 investment. So you want to make sure that you're talking to people when you're looking into this option who understand those subtle differences, because that's critical for making sure that you have a successful application.
Yeah, like Lakshmi said, there are a lot of nuances in Mukesh, the job creation, and also, where, if you have your own project. So there are a lot of things. So send me an email, or send email to info@Chala, and I'm glad to call you and we can talk in detail. And I'd love to visit the project site that I've taken so many people in the last 3 weeks, Greensboro, North Carolina, right? So
and then I wanted to say, we've got so many people on YouTube. You YouTube folks, thank you for joining. And can you let me know how you found out about our live YouTube webinar? We'd love to know, to see how you connected with us. You all have been, we've seen that there's been an increase in questions and activity on YouTube, and it always helps to know how you obtained the information. So if you could put it in the chat and just let us know, that would be great.
This question was answered from YouTube, but I'll ask again. Can you interfile when the dates are current only in data filing chart and not FAD?
No, you don't have to wait for, you can interfile at any time. You don't have to wait for the dates to be current to interfile. You're just merely telling USCIS, hey, USCIS, I have an approved EB2 and I have an approved EB3. Please use whichever one is current for processing my adjustment of status. That's all you're doing.
And I think that's about all for now. Don't see any questions.
Well, I want to thank my team for putting all this together, specifically Kara and Lainey for everything they do in the background to make this look as seamless as it is for Shaker and I. And please join us next week. I think it'll be a great event, and share it with your friends that may be interested in traveling and want to understand about any restrictions in terms of processing. We're going to have our guest speaker who helps people out processing in Mexico to give us the latest update. And if you haven't done that, please connect with us on YouTube. We've got a lot of YouTube channel. We've got a lot of really great resources, as we've demonstrated with the links on our YouTube channel. And the only way you'll get notification if we've posted anything new is if you subscribe. And I'd love it, as a personal favor to the Chala Law Group, if you would share that with your friends. and comment. Let us know what you liked. Let us know what you didn't like, so we can make sure that we structure our content to the ways in which it can help you the most. We have a community called the Telegram group, a community of people that are going through the immigration process themselves. And in addition to having a great group of people that are helpful with sharing resources, we monitor that as well, and we chime in. And we're one of the few where we don't charge you for the answers. I mean, most other communities, when I tried to give free information, I was kicked out because they said, we don't want you to give free information. We want to charge people for this. And I thought, that's not fair. So that's why we've created a Telegram group. So please join our Telegram group if you haven't, and share it, share those links with your friends. And then, of course, there's Facebook and Twitter and Instagram, you know, and we use those different platforms for different types of communication. And if you have any questions, further questions, email us at info@chellalaw.com. So I want to thank Shaker Chella for the moderator with the bestest, for, even though he got up at 3:30 this morning and he's traveling, it's great that he was able to join us today.
Well, thanks for the opportunity. I won't miss seeing you. So, you know, what can I say?
Well, thank you.
So the team has put all the links for all the social media, and, you know, let me tell you one thing. Information overload sometimes is not good, but when it comes to immigration, information overload is good. You should be on top of your immigration.
Absolutely.
I have a long story. We have a long story.
One day,
Yeah.
perhaps not today, but one day.
It's
we'll
like a
tell the
Bollywood movie.
story.
And I narrated. I hope some director will pick up and write a screenplay and maybe make a movie out of it.
You think you'd like to play you?
No. Like that guy, the guy who makes all these Telugu movies, you know, he always makes movies in the NRI community. I forget his name.
Right, Kunal something.
Happy Days, the guy who made Happy Days, the first movie. Sorry, folks who are not familiar with Telugu, but great movies. So.
Well, thank you, everyone. Thank you, YouTube. Thank you, Shaker. Thank you, Karen Laney. And we'll see you next week, again, at Wednesday at 12 o'clock Eastern Standard Time, and where we'll be talking and trying to help you if you're planning to travel during the holidays. Till then, take care.
Look out, next week is a big surprise. Your attorney is going to talk about something big. Something big is happening next week. So that's all.